Well, good morning and welcome to the 10th meeting of the Economy, Jobs and Fair Work Committee. May I ask everyone to turn their electrical devices to silent or turn them off if they're likely to interfere with the sound system. The first decision for the committee is to take item 3 in private. Are we all agreed?
Yes.
Thank you. Now we have with us today for our consideration of the Bankruptcy Fees Scotland Regulations 27, our first panel of witnesses. Welcome to all three of you. First of all, Mike Daly, who is Principal Solicitor, Parliamentary and Social Policy Unit at the Govan Law Centre. Next we have David Mingus, Director of Insolvency at ICAS, and Alan McIntosh, who is Project Manager, Personal Insolvency Law Unit at the Govan Law Centre. So welcome to all three of you. May I first of all ask the committee members if there are any interests to declare? Bill Bowman.
I'm a member of the Institute of Chartered Accountants of Scotland. Note that.
Thank you. And John Mason.
Yes, I'm also a member of ICAS.
Thank you. Well, may I start, first of all, I think both Mike Daly and David Mingus have submitted papers to the committee, and perhaps I could just ask, just to start us off, first Mike Daly, the principal points that you would like to make about the particular regulations that we're looking at today, and then I'll ask the same of David Mingus, and then we'll move to questions from committee members. No need to operate the buttons in front of you. That will be done by the sound desk.
Thank you, Convener, and thanks for the committee to invite Govan Law Centre to give evidence this morning on the draft bankruptcy fees regulations. So to briefly summarise the concerns that Govan Law Centre have with respect to these proposed regulations, it's worth noting the stated policy objective of these proposed regulations is to ensure the bankruptcy fee structure in Scotland remains appropriate and fair. Now, the notion that fee increases of almost 200% can be appropriate or fair, in our respectful view, doesn't make any sense. We believe that these proposals are regressive, we think they're unfair, and we think they're punitive. To take one very quick example, if I may, Convener, under the current rules, the AIB would charge a fee of £2,800 on the repossessed sale of a family's home, which had £60,000 of equity. Under the proposed regulations, those fees would rise to £8,000, representing a 183% increase. Now, I think it's important to remember that that cost of £8,000, which has been proposed in that scenario, is in addition to the cost that a homeowner in Scotland will have to pay in terms of legal expenses during that process, which could be many thousands of pounds. And in addition to the costs of the sequestration itself. And I've certainly seen many, many people who've been made bankrupt for, say, £3,000 to £4,000 of, say, council tax or tax generally, and you will end up possibly with £15,000 to £20,000 in general fees in terms of sequestration. Now, here's the point. What's the justification for this massive increase? As far as we can see, it's to subsidise primarily the AIB's deficit due to a drop in cases over time, so it's its own costs, and also to cross-subsidise, to a smaller extent, a cap on the fees of insolvency practitioners, the fees that the AIB charges to insolvency practitioners. So our concern is that this isn't fair. At the end of the day, where's the value for money in this process? A process which ultimately is being paid for, at the end of the day, by Scottish consumers. But here's my final point, if I may, Convener. We think there will be unintended consequences from this policy. And that is, I fear, the situation whereby somebody's sequestrated, they have equity in the house, they're going to get repossessed, unless we can defend them. And we do defend many people. But let's say they get repossessed, these fee hikes go up. The chances of that person, or it could be a family, getting some money back out of their equity is substantially reduced. And what that means is that their ability to have some money, for example, to pay for a deposit in a private rented flat, or to have sufficient money that, for example, they might be able to put that money somewhere, get back on their feet, and maybe buy a property that's cheaper all of that is going to be diminished, which has an implication for more applications to local authorities as a homeless person. So the public costs in this are going to be something that's never been factored in by the AIB or in the impact assessment. So the only thing that's been missing in the impact assessment is the impact it has on the people of Scotland. So that's our concern, and we are calling for a full review of the way that the AIB is funded, so we don't have this piecemeal approach, because it's not sustainable. Thank you, Convener.
Thank you. And David Mingus.
Thank you very much, Convener. Also, similar to Mike, I guess, I very much welcome the opportunity to present the evidence to the committee on the statutory instrument. The committee have already received my letter to the convener, so a lot of my detail is within that. But I think it is important to recognise that the AIB is a public body and that statutory fees are necessary. So we're not opposed to statutory fees in total. It's just how that is made up, essentially. So the statutory fees are certainly a necessary part of the AIB's operational income. I think it's important for the committee to understand that statutory fees are ultimately payable by the end recipient of the process. So in the main, that is likely to be the creditors, because they will either be the ones that are receiving a dividend or not receiving any dividend at all. But as Mike has already alluded to, there are occasions where there's what we would call a reversion. So where all the assets are realised, all the creditors are paid in full, and there is still some of the debtor's estate left over, and that will go back to the debtor at that point. So ultimately the fees are payable either by the creditor or the debtor in those circumstances. The government fees in total, or take out of the costs of bankruptcy, are actually quite substantial. Most personal insolvencies are not VAT registered, they're private individual people's. So by the time you add on 20% VAT, the 15.5% audit fee from the AIB and the other statutory fees, then the costs of that insolvency process are probably increased something in the region of 40 to 45% in total. So that's quite a substantial increase in burden on the estate in the first place. The fee proposals that are being put forward are certainly significant percentage-wise in many instances, although it is recognised, I guess, that some of that is relatively small in terms of individual monetary value. You know, an increase from £19 to £50 is not a huge amount in pure pounds, but percentage-wise, it's a fairly significant increase. It's likely that, certainly in terms of some of the creditor fees, that burden will be felt by other areas of the public purse. It's likely to affect HMRC and local authorities in particular. The fee increases will be paid by them. Approximately 2/3 of individual petitions of sequestration are made by HMRC or the local authorities. So predominantly, certainly the increase in that petition fee will be felt by the public purse elsewhere. We certainly welcome the cap on the AIB audit fee on practitioners. It's certainly a step in the right direction. However, the cap itself of £5,000 is going to affect very few cases, and it certainly does not affect the AIB's income in some ways. And I'm happy to provide examples later on, if need be, in terms of the complete unfairness, if you like, of the audit fee and the lack of value for money, I guess, that provides. The regulations also provide for interest to be charged on late payment of fees. That particular aspect came to us as a surprise. There was never any mention of that as part of any consultation process. Again, we're not necessarily opposed to interest being charged. I think it's absolutely right where an insolvency practitioner firm does not pay the amounts that they're due when they're due, then absolutely there should be interest charged. I think, you know, as I say, it's really around the consultation process and also the level of the interest that's charged. The 8% interest has been described by the Minister previously as being punitive, and I think that's probably correct. I think when we look at the low level of interest rates at the moment, that's not a sustainable level. I think in terms of the interest, that certainly must not just simply become another source of income for the accountant in bankruptcy. It really should be reserved for the cases where there's a need to take further action against somebody that's not met their obligations. I think, as Mike alluded to, certainly we're now in a new position of historical lows of personal insolvency rates. My expectation is, I think, certainly that low level will be continued for quite some considerable time. I don't think we're ever likely to get back into the position where we're seeing 24,000 people per year declared bankrupt in Scotland. So we're in a position, I guess, where we've got a potentially an ever declining circle, which obviously impacts on the fee income, which then circularises, to requirement a further increase in fees as we go on. That's not a sustainable position. So I think I would agree with Mike in terms of saying actually probably now is the time for a fundamental review of how the agency is funded, how the fees are set, how that's structured going forward. And I think also there's a level of conflict of interest within the AIB in terms of duplicate functions that are carried out elsewhere, that again, perhaps that role and function cannot necessarily be ignored as part of the setting of the fee regime going forward.
Thank you very much, Mr. Mingus. Mr. McIntosh, we'll bring you in as and when, but perhaps we could move on to questions at this stage. If any of you wish to comment or respond to the questions raised by committee members, please simply indicate by raising your hand. I'll start off with a question from Richard Leonard.
Can I just pick up, Mr. Mingus, on the very last point that you made, which is about the potential conflict of interest between the accountant in bankruptcy, both as a kind of practitioner and as a policy advisor. I wonder whether you could perhaps develop that a little bit more for us.
Yeah, I mean, certainly it's a concern that ICAFs have had for many years. As I say, I think that, there is a large number of functions which conflict with each other within the agency. They act certainly as the policy advisor to the Scottish Government. They act as a quasi-regulator to the profession. They have supervisory duties, which conflicts, I think, with the policy advice situation. They actually act as the provider of accountancy services, and again, that must conflict with a policy advisor position as well. And then beyond that, I guess, as well as being the actual carrying out of the case and supervisor of the cases, they also act as decision maker and appeal adjudicator in many instances as well. Now, it's all fine and well saying, well, we can put in Chinese walls or separate teams and such like, but down in Kilwinning, actually the building's not that big. It must not be possible to keep everything completely separate apart down in that building. So, those conflicts of interest must exist. Some of the functions, I guess, are superfluous. The regulatory function really has come in from the Bankruptcy Act of 1913. We've moved a long way in terms of regulation since then. The Primary Act, as you're probably aware, up until last year, was the 1985 Bankruptcy Act. That was brought in 1 year before licensing of insolvency practitioners was brought in. So we now have a fully robust regulatory regime for insolvency practitioners, which must bring into question what is the purpose of another layer of regulation that the AIB carries out, and what actually does that add to the process. So those additional layers and conflicts of interest certainly bring in the additional costs as part of that overall process.
Thank you. I just ask to the committee members and witnesses to keep your answers and questions as succinct as possible, because we're fairly limited in time. I'll move on to a question from Jackie Bailey.
I will try and be very brief, Convener. We understand that there are 533 bankruptcy awards made through creditor petitions for HMRC. It represents 38% of the total. How likely do you think that HMRC will withdraw and seek private insolvency practitioners, as they've indicated they might?
As you say, they have certainly indicated that they are looking at it. From discussions that I've had with officials within HMRC, that's a real prospect, I would guess. So yes, I think it's later.
And I was quite interested in your figure for local authorities as well, that they represent between HMRC and local authorities 2/3. Do you think local authorities are likely to follow suit then?
There are certainly some local authorities that have already done so. Glasgow City Council, for instance, has a panel, if you like, that they will prefer to put it out to a private trustee rather than to the IB. So it's likely, I would imagine, that other local authorities will follow suit as well.
But let me state the obvious. What does this do for the future sustainability of this kind of fee structure?
It's not sustainable in that simple form.
I mean, if I could maybe come in, one of my biggest fears is as well as what was going to happen, and we've seen this before. I mean, I would describe insolvency laws and also the fee structure as almost being a complex algorithm in the sense that, you know, when you start tweaking with one bit, it has unintended consequences. We've seen that maybe even as early as 2012, when, for example, we raised the cost of low-income, low-asset bankruptcies from £100 to £200, and we've seen a sharp drop-off in the number of people that were able to access low-income, low-asset bankruptcies. That's now being reversed. We've introduced the minimum asset procedure in April 2014, and the fees now come down to £90. So my concern is that this unsustainability of the accounting and bankruptcy going forward, because they're reducing caseload and the policy of full cost recovery, is what we eventually come down to eventually is we're going to have to start hunting for other places we can find fees. So, you know, maybe we come back and maybe in a year or two's time we're looking at how much it's going to cost a debtor to apply for debt relief, you know, and maybe we're not looking at £200, we're looking at £300 or £400, and I think that then creates barriers and it creates access to justice issues. We've already, I mean, previously, prior to 2008, for example, if you were on an income-based benefit, you used to get a fee waiver because it was done through the courts, and the Legal Aid Board would give you a fee waiver. That's no longer possible. So I think there's a danger, and one of the reasons we had a big spike in bankruptcies in 2008 was because with the Bankruptcy, Indulgence, etc. Scotland Act, we removed one of the legal obstacles or one of the legal barriers apparent insolvency for a lot of debtors to be able to go bankrupt, and that led to a massive spike in the number of bankruptcies. I think there's a danger going forward that we're going to start replacing legal barriers with financial barriers and financial obstacles to people, and that really does create a big access to justice issue.
One tiny question. You all in your submissions have said that you think that there should be a full review. Do you, as a starting point, believe that there should be full cost recovery?
Can I answer that question, if I may? I think, and this comes back to Richard's point as well, in terms of this conflict, the policy, and David's talked about this, the policy of resting with the AIB. Now, here's the real difficulty. And to answer your question, it's no. But here's the real challenge. The rest of our legal system, the courts, even the Employment Tribunal, although the Employment Tribunal is not in a great place in terms of fees, but there still is fee remission for employment tribunals, and there are for courts based on income. There isn't for the AIB. How can that be right? If you accept that the AIB is undertaking some quasi-judicial functions that used to be in the Sheriff Court but have now been passed to AIB, ordinarily, if you were on a low income, you would not have to pay fees. But you do have to pay fees. So why is that? Well, the reason for that is the very point about the conflict of interest, because the AIB is setting the policy, and that can't be right. So, and just final quick point is that when it comes to accessing justice, which the AIB is doing some of, then actually, I mean, it goes back to the Magna Carta, it goes back to habeas corpus. It's actually, why do we have, because I was involved in some of the work that led to challenges, because we never had fee remission in Scotland for a very long time. And what it leads back to is that there's a constitutional right in Scotland, and indeed the rest of the UK, that when you access justice, you're not accessing a commodity in the sense of buying a tin of beans and you've got a choice. Often you're accessing it because you've got no choice. So there has to be an element of being able to access justice if you're very poor on a low income and not being hit with these charges.
Andy Whiteman.
Thank you, Convener. Have any of you done any calculations as to what would be the impact on the accountancy and bankruptcies forecast deficit, which in the policy note is described as 1.3 million in 2017-18, 4.2 million in 18-19 and 3 million in 2019-20. What would be the impact on that deficit if this fee order did not proceed and we remained with the existing fee order?
Well, I mean, I think one of the things that's actually said in the business and regulatory impact is that in terms of the actual fees in relation to the Commission for Recovering Inheritable Property, which is the house issue, that the benefits of that will be passed on to the accounting bankruptcies agents, and that's actually what, because accounting bankruptcy don't always actually administer a lot of bankruptcies, they have agents they instruct to do these things. And one of the things that is noted in the business and regulatory impact document is that these fees, in relation to heritable property, obviously the audit fees are different, but I think you know, that these fees, what the benefits are getting passed on to other agencies. So I don't even know if the AIB, how much the AIB will benefit directly from those fees, or whether it will go to their agents.
I mean, certainly I don't have access to figures that would allow me to do that calculation. I think a lot of that is very much dependent upon information that only the AIB will currently have. So I'm not able to specifically assess that. But you know, certainly I would imagine the impact of not doing this will be exactly what they've said in the policy statement in terms of where it's likely to impact on their fees and those levels.
Just very quickly, if you think about the real world for everybody else, whether it's public bodies, whether it's charities in the third sector, is we've all had to deal with cuts. We've all had to absorb the pain of austerity. The AIB must be one of the few, if not the only body in the country that seems to be in a bubble. And this is why our concern is that who's paying for this? And it can't be right it's coming out of the equity of somebody who's paid their mortgage all their life, they ended up going through hard times, going through trauma, and then the AIB come along and take a 188% increase from their house. That can't be right.
Can I possibly make a point here as well? In the regulatory or business regulatory impact document, one of the things it does say is it identifies the people who will be impacted with this as has been the creditors and solvency practitioners. And I find that quite disturbing because I've got two cases here, one from Ross and Cromarty, one from South Lanarkshire, from Citizens Advice Bureaus that I've dealt with in the last week, which involve, in both cases, young women that have actually got homes with young children in them. In one case, the young women, you know, if their house is sold, the difference is going to go from 2,500 to 6,750. In the other case, you know, if the house is sold, it's going to go from 3,400 to 9,500. Now, these are cases where there would be a reversion of funds back to the debtor. So they are losing their home, and in terms of vulnerability, you know, I don't think bankruptcy gets any more harsh than that you will lose your home when you've got children. And these are cases where these people are going to see a dramatic increase. And ultimately, one of the things that the AIB say in the policy document is that ultimately the cost of bankruptcy or sequestration is borne by the creditors. That is absolutely not true, because in some cases like these, it's actually borne with the debtor. And these are people that are paying £100 back, 100 pence in the pound back to their creditors. They're paying for the cost of the administration of their bankruptcy. They're losing their home, and they're also paying the 8% statutory interest in their debts, which the Minister himself has described as punitive, and they were going to introduce massive increases. And that to me just seems blatantly unfair.
Could I just give some context to that, I guess, just very, very briefly in terms of figures, I guess. That roughly equates to about 4% of all sequestrations per annum result in a reversion back to debtors, and that equates to roughly about 260 individuals per year, just to give it some context there.
Thank you. And Gil Patterson and then Gordon MacDonald.
Back to a point that Mike Daly made. It's not actually a review you're really looking for. You're looking for a suspension, then look to come up with a new system, as I understand it.
I think that's right. I think because obviously, because these draft regulations have been laid and this committee is the lead committee, if they're not, I suppose they would technically have to be rejected. I don't know. But if that's not done, then clearly we're going to have a difficulty here. So I think you're absolutely right.
That's what we're looking for. The other point is, in regards to the percentage of those who are not paying or slow paying, if it's not 8%, what would you suggest to the committee would be a more reasonable figure?
Well, I mean, I remember discussing this at a round table when Hugh Henry was the Justice Minister, and he agreed. And as my colleague Alan has said, Paul Wheelhouse, the Minister, agrees as well. I mean, 8% is, I mean, goodness me, nobody's getting 8%. I mean, if you look at any current, if you look at a savings account, even an ISA, the banks in the UK have actually reduced the rates on ISAs. You get a better rate on a savings account if it's not an ISA, because the base rate is at 0.5%. So the idea that you can get 8%, and sometimes there's years and years before these cases are ultimately fully wound up, I think that is it's got to be something above the base rate. We could look at other jurisdictions. I mean, I think, Alan, what's the position in Ireland?
The situation in Ireland, the Republic of Ireland, I've also had an insolvency practitioner there, but the situation there is that in December, they've always been tied to us and had the same 8% rate that we've had in the UK, but in December, the Irish government reduced it to, I believe, 2%. In terms of judicial interest and also statutory interest, they've reduced it already.
And then my last, were you wanting to?
I was just going to say there was a Law Commission report a number of years ago that's looked at the judicial rates of interest, and it was suggesting pegging it to base rate, and something around 1.5% above base rate, and peg it that way so that it fluctuates.
And my last point was in regards to the notion that insolvencies are going to remain slow. Can you give us any information why that would be? That's what your thoughts are?
I think there's a realisation, I guess, within the creditor community. Ultimately, I guess the creditor community are in the main commercial businesses. They want to get as much back as they possibly can do. They recognise that in this day and age, that it's better to work with creditors, with the debtor, to get something back than to get nothing back out of bankruptcy at the end of the day. The regulatory system around the Financial Conduct Authority about treating customer fairly, that has a big impact on how creditors will deal with the debtors. So there's certainly no rush now to declare somebody bankrupt. You will see from the figures that the majority of bankruptcies are actually voluntary led, so they're led by the debtor rather than by the creditors. So again, unless there's some sort of social change, I don't expect any change in that. So everyone's really predicting, yes, okay, there might be a small increase in insolvencies over the next few years, but certainly nowhere near back to the level of 24,000 that we were seeing 6-7 years ago.
I mean, just to add to that, I mean, I think, when we did see that 24,000 or so, maybe 10 years ago, one of the reasons for that was because there was legal obstacles that were removed that allowed people to actually go bankrupt with the Bankruptcy and Diligence, etc. Scotland Act. So there was a build-up of people, plus also there was actually a build-up of historic debt, and we've actually dealt with a lot of that historic debt very well in Scotland. In actual fact, I think there's probably been probably excess of 160,000 insolvencies since 2008, and when you compare Scotland with other jurisdictions like Ireland, who had a very antiquated insolvency system, they're still trying to deal with their historic debt from the pre-credit boom sort of, or the sort of pre-credit crunch sort of era. Scotland, we've been actually very effective and very successful, and now people have other remedies as well, like the debt arrangement scheme, which allows them to avoid using insolvency. So I would agree with David on that.
Could I come to a question from Gordon MacDonald now, please?
Thanks very much, Convener. Mike, I wanted to ask you about the information you had in your paper. You said that there had been no significant reduction in staff costs or AIB costs overall over the last 9 years. But would you not accept that those are, they don't reflect any inflationary increase? Looking at the Bank of England's inflationary calculator, 2008-9 AIB expenditure was £12.4 million. To reflect that in 2015-16 would have suggested the figure should have been at £15 million, and it actually came in at 12.2. Would you not accept that there has been a cut in the operating costs of the AIB over that period?
Well, I accept what you say, and that's correct. But what I would argue is that applies across the board for all public bodies, and not only and it applies actually across the board. And this is, I think, the point my colleague Alan was making, which is that because at the end of the day, this is ultimately real people that are paying for this. Typically, people have not had wage increases, or it may be a 1% wage increase. People that then end up in social security benefits have had them frozen. So the voluntary, the third sector, the public sector, they've all experienced that real cut. And of course, the Scottish Government itself has experienced massively big cuts in their budget, and that's all been passed on, and local government too, of course. But the point is that why should the AIB be different to any other, a council, a non-departmental public body, a charity or indeed a business, because if somebody was running a private business and their case numbers dropped and their income dropped, if you tried to just simply double your fees, you would discover that in a competitive open market, people would say, well, actually, I'm not going to use your business, I'll use somebody else. So, and this comes back again to Richard's point about the conflicts here. You can't get anybody else. That's the problem. So we've created this creature, if you like, that is doing a lot of good work. I mean, we're not saying it's not doing good work, but what we're saying is because of all the conflicts, it's ended up in this mess of a situation.
I mean, I'm not disagreeing with anything you're saying. I'm just trying to get to the background to your figures, that's all.
Sure.
Right. So, again, AIB staff numbers. You've got at the very high peak of 22,410 insolvencies, 140 staff, and they're currently around about that 140, 145 staff. But before that peak, back to 2006, 7, immediately before that large peak, when the cases were around about 6,000, they were still at 140 staff. So are you saying there's too much slack in the system, or I mean, how did they cope with that peak when their staff levels seem to have been more or less consistent, although it did go up a wee bit during 2008 and 9, etc.?
Yeah, possibly, if I can come in there. I mean, one of the things that we also have to factor in here when we're comparing figures with 2006 is that the insolvency system in Scotland has dramatically changed. We've seen massive, improvements in terms of software with Basis, Astra, with the Dash system. We're moving away from clerical applications to actual online applications. So we've actually seen with the Bankruptcy and Debt Advice Scotland that a lot of additional roles and administrative roles can actually been placed on the free sector and advisors. So I think, when we are making comparisons, we need to realise that there has been a lot of moving in the furniture. There's been a lot of technological advancement, which would also suggest you would expect to see a reduction in terms of the time required to administer cases and also the cost involved as well, which I think has to be taken into consideration.
Well, that's right. And very quickly, in terms of, say, the rest of the public sector in Scotland, what's really happened, although there is a Scottish Government no redundancy policy, what you find happens in practice is that when people perhaps retire or when people move out into a different sector or move completely, the posts are not filled. And so there's lots of organisations that are having to operate with unfilled posts because they've had to. Because normally your staff costs are your biggest outlay, so they've had to do that in order to cope with their settlement deal in terms of their budget. But the AIB is not doing that, and again, not to labour the point, but our concern is that it's quite perverse that it's able to do that at the expense of very vulnerable people.
And just my final point is, with a vast reduction in the number of cases, has there been any change in the complexity of the cases?
I wouldn't say there's been any substantial change, no.
Okay, thanks.
Bill Bowman.
Thank you, Convener. I think David Menges said at the beginning that there were conflicts of interest within the AIB. If you were to resolve those, would that add extra cost, or are there other bodies that could take over some of these functions of regulation or whatever you were thinking about?
I mean, certainly, when you look purely at the regulatory system, as I think I already mentioned there, we now have a very robust regulatory system for insolvency practitioners within the UK. That licensing system has been there since 1986 now, and works pretty well. The regulatory function that the AIB currently has is really historic from 1913 Bankruptcy Act, when we didn't have that regulatory system there. So there doesn't seem to be any real function now for the AIB to be duplicating that regulatory function. So certainly, if that was taken out, I would imagine there would be elements of cost to go out with that. I have no idea how much that is. The public accounts don't disclose that in terms of a divisional reporting basis, if you like. So, but just the logic of that, there must be an element of cost that could be removed. Yep.
So the conflicts could be resolved without just putting in place yet more cost?
Yes.
That's really, yeah, yes.
And John Mason.
Thanks. It was really to follow on from Gordon MacDonald's line of questioning. I mean, are you clear how much of the AIB's costs are like fixed costs? So whether they've got 10 cases or 5 cases, that cost base is inevitably the same. and how much of it is linked to the actual number of cases they have. And I suppose, and then, well, okay, if we start with that, I mean, do we know that at all?
But, I mean, what we do know is, I mean, we've talked about the numbers of staff kind of remaining the same, and I think we've provided evidence, and of course the AIB have provided evidence on an annual basis that their cases have dropped quite substantially. Now that must mean that if you did a cost by case analysis, the cost of their cases have shot up, which is perhaps no surprise that the cost of the fees are going up, because that's what's happened. Now, the ability for that to happen in that way, we say, is very unfair. Because if you look at other public bodies, they're not in a position to do that. I mean, but we do have other public bodies that can charge fees, but we certainly don't see fees. I mean, looking even at local authorities in terms of registration processes and so on and so forth, we don't see that massive hike in the public sector in the country. So it's a very peculiar thing, and we think it's because of these issues of conflicts and because of effectively you're operating within this bubble, and that's why we're saying it needs to be looked at in the round.
Get that point. I can ask them. Maybe it's fairer to ask them. I mean, the other side then would be, you know, if we're saying there is it £30,000 equity. This is your figures, Government Law Centre, I think. 30,000 equity. The fee would be £4,500. Double. But 60,000, it would be £8,000, so it's, well, roughly double. I mean, presumably the actual cost to the accountant bankruptcy is not double because the estate is double, is it?
Can I give an example of that? I mean, you could have two people living next door to each other, you know, somebody in their 30s and somebody in their maybe 60s. They're exactly the same house. The first person in their 30s, because, and that's raises an issue about equality, which I don't think has really been dealt with either in this, the business and regulatory impact, because it doesn't identify the debtor as somebody who's been potentially impacted this. But and therefore, I think we've maybe missed equality issues. But you can have somebody who gets one house sold, they've only got £10,000 equity because they've got a £10,000 mortgage, and the AIB takes £1,500 because that's 15% of £10,000 equity. The person next door, they've maybe got 100% equity, so they've got £100,000 equity because they've no mortgage because they've worked all their life, they've paid their debts, no, they've actually paid their mortgage off, and that person, the cost they have to pay is £10,000. So it's disproportionate, obviously, because it's based on equity. The cost of actually selling both houses is the same. Then maybe the work involved in doing administration and the bankruptcy is the same, but the person who's actually maybe got the equity, possibly an elderly person, I would expect that would be more likely to be the case. No, they disproportionately pay a bigger cost to the actual for this system, because ultimately, you know, it's on a sliding scale.
The argument will be its ability to pay, but we can take that up with the Minister and so on. I mean, the £1,500, which is the minimum one, do I take it that that would not cover the accountant and bankruptcy's costs? That they're actually... This
is a commission, so this is, I would imagine, maybe David can confirm this, but this would be in addition to the cost of actually selling the property, I would imagine.
That's correct. So the basic fee, which is, I think, the very first one that's listed in the schedule, that is just a fixed cost no matter whether a case has assets or no assets, essentially.
I would think as an accountant, I would be thinking if I did an audit, it would be so many hours at so many pounds an hour. Yep. Is there any relationship with that in here?
I think within the policy paper, the AIB set out how they actually came up with that figure, which was basically their fixed cost divided by the number of cases multiplied by the 4 years.
So we're back to fixed costs again. It's
yes.
not the case.
Yes.
Costs.
Yep.
Right. Okay. Well, that's helpful.
So that's a basic fixed cost fee.
Okay. Well, I'll pursue that with them later. Yes. Thanks. Cheers.
Are there any other questions from committee members? Dean Lockhart.
Just a very quick one. The fees we were discussing relate to the bankruptcy of individuals, sole traders and partnerships, I understand. Can you give me, don't need the detailed numbers, a rough breakdown of, if we're looking at 4,000 cases this year or last year, what would be the breakdown between individual bankruptcies, partnerships and sole traders?
I'm not sure. I certainly don't have access to that information. The accountant in bankruptcy would
be able to provide that. I
Just
think.
a quick supplemental then. I think most bankruptcies are voluntary in terms of the the debtor volunteering to, after advice from a money advisor. Do you have a rough idea of when it comes to individual bankruptcies, what proportion are voluntary versus being forced into bankruptcy?
I think maybe as much as 80 to 90%. I mean, high 80s are actual voluntary, and maybe less than 10% are actual debt. That's just, I mean, it was about 86% a couple of years ago. I don't know if David's got more up-to-date figure, but actual voluntary, well, and that's a complete reversal for what it was about 30 years ago.
Certainly, in the last fiscal year, there were only 3,765 creditor-led actions in that year. So
And
it's certainly in the minority. Yep.
Right. Yep. And just when it comes to voluntary bankruptcies, what would be the main cause? What would be the main trigger encouraging someone to seek voluntary bankruptcy?
Usually they would go to a money advisor. I think obviously people who have financial difficulties, they go to a money advisor. One of the things that were brought in with the Bankruptcy and Debt Advice Scotland Act is that you now need to receive advice before you can go bankrupt. So I think most people would go to a money advisor. The money advisor would look at all the options, including the debt arrangement scheme, and it would be on the advice of the money advisor or the insolvency practitioner that a debtor may apply for their own bankruptcy as being the best option for them. Creditor petitions tend to be, and usually these wouldn't be the cases, I would imagine, that would be affected by these big fee hikes and realising assets, because most money advisors wouldn't advise somebody to go bankrupt if it meant losing your home. They'd look at another option like the debt arrangement scheme. So these cases really impact primarily, I would imagine, on creditor petitions, where it's a creditor that takes a court action to force somebody into bankruptcy.
Right, thank you.
All right. Well, thank you very much to our witnesses. That concludes this part of our session. I'll suspend the meeting, and thank you very much to all three of you for coming in today. Thank you. Well, welcome back to the second half of this morning's session. I'd just like to welcome Paul Wheelhouse, Minister for Business, Innovation and Energy, and also Graham Fisher, who's Head of Branch Legal Directorate, Constitutional and Civil Law for the Scottish Government. Richard Dennis, who's the Chief Executive Accountant in bankruptcy, has been unfortunately delayed in traffic. So we'll commence without him having discussed that with the Minister. I think he's happy to commence. Well, and I think there is a representative from the AIB present in the room who should feel free to pass notes to the Minister if there's any issue that is felt could be assisted with during this session. May I just check, Minister, first of all, have you seen the papers from ICAS and from the Govan Law Centre?
I have, yes, Convener. Yes, that's great.
Good. And there's a number of issues raised in these which will be no doubt covered by members of the committee, and you'll be given an opportunity, of course, to respond and comment on matters as they develop. I just wanted to raise, first of all, perhaps not the first issue, but it is an issue that's been raised about the rate of interest that is proposed to be introduced by the regulations. The rate of interest at 8%, and I think you'll have seen the quote from yourself in the ICAS submission referring to 8% as seemingly punitive. Now, I think Graham Fisher may also be aware of the current state about the judicial rate of interest, which is 8%, which seems to have been the basis for this. And of course, in a courtroom situation, a judge can modify that interest, and I don't think there will be any similar provision for modification in the regulations that we're considering today. And of course, the issue of that rate of interest was considered by the Court of Session in the case of Farstad Supply AS on the 20th of February 2013, so over 4 years ago. And what was said in that case when the Court of Session upheld a decision by a lower court judge to reduce the rate to 4% was that it is plain that the mismatch between the judicial rate and interest rates prevailing in the financial world, which has existed following the crisis of 2008, is a matter of concern. That was at paragraph 31 of the judgment. So I'm just wondering why one would think of introducing, in terms of these regulations, a rate of 8%, or what your views are on that, considering it's been raised as a matter of concern that it should be that high by the courts themselves, which seems to be the basis of this rate of interest.
Well, it's an important point, Convener. I was going to address a number of things in open remarks, but if I may, that would be very helpful. But I'll start with that just so that in the sequence it's easier to address. I think I have correctly, it's been cited that I've put on view my view that I think the judicial rate of interest is too high in the current context. We are anticipating the UK Government is going to be undertaking a consultation, UK-wide consultation on the issue of judicial rate of interest, and we hope to learn from that and be able to adapt the rate that applies in Scotland accordingly. If that doesn't come forward, it's taking longer to get started than we had originally anticipated. We'll obviously have to review our position and perhaps do something unique to Scotland and to take a lead on that issue, but we are still of the view that that consultation will take place UK-wide, and we'll obviously be able to benefit from the input from stakeholders about the appropriateness of using an 8% judicial rate of interest as the basis for these kind of decisions in due course. But I do acknowledge that it's a high rate. It's worth stating that the rate that is applied is not applied across a large number of cases. For example, there's two debtors account for 59% of the aged debt that we have on the books, which is debt due for more than 30 days, and that totals more than £230,000. And of this, around 80% of this aged debt relates to protected trust deeds. And given funds are gathered from 1 month of the trust deed being protected, the argument that these should be paid from an insolvency firm's own funds should not really hold true, we believe. There is an issue around if there were sort of court fees or therefore if the there were statutory fees that were being applied, there wouldn't be a question about the need to pay quickly. But if, I will go through my opening remarks, Convener, and perhaps then
yes,
bring in Mr Fisher, who's got some knowledge of the case that you outlined earlier. Convener, thank you for the opportunity to address the committee this morning. And these regulations clearly update and replace the Bankruptcy Fees Scotland regulations of 2014. And for the most part, they apply to bankruptcies arising from debtor applications made or creditor petitions received on or after the 3rd of April of this year, and protected trust deeds granted on or after this date as well. And previous fees will continue to apply to pre-existing cases, and I think that's just important to make that point. I believe there is a clear case for the regulations to come into force in their current form. Ensuring that the people of Scotland have access to fair and just process of debt relief is a key priority for the Scottish Government, and I believe we have a strong track record in this regard. The Accountant in Bankruptcy, or AIB, is the office holder responsible for these processes, and oversight of the AIB's role and performance is a ministerial responsibility for my portfolio, and I am of course accountable to Parliament for ensuring that the funding and administration of insolvency strikes the right balance between drawing upon public funding and generating fee income for helping with cost recovery. I believe it can be shown that AIB achieves this balance, and in my view, we have a personal insolvency regime that stands favourable comparison with any other in the UK. And by way of context, in 2016-17, AIB's parliamentary approved budget was £2 million after the spring budget revision. Forecast reductions in operational income due to changes in the number and composition of cases will see this public funding requirement increase to £4.2 million in 2018-19. And in that context, it's worth stressing that the measures introduced in these regulations will only provide an estimated £207,000 of additional income to help offset further requirement for additional public funding. And the question is whether the balance between extra funding from the taxpayer and extra income from creditors is the correct one. Clearly, continued efficiencies within AIB will play a vital part in minimising the impact on the taxpayer. AIB staff figures show that in 2009-10 there were 173 full-time equivalent staff, and 2015-16 this had dropped to 139, a drop of 20%. And I'm aware that the committee has seen papers from other witnesses, but I would stress that they do not accurately, in our view, represent the change in personnel numbers in recent years. And over the equivalent period, AIB's funding requirement from Scottish Government has reduced from over £4 million to the current position. Furthermore, it's important to note that in the last 3 years, AIB has introduced 3 major public-facing IT systems, all within time and budget. Each of these has the specific aim of simplifying procedures, reducing administrative effort and increasing efficiency in processes, not only for AIB, but for money advisors, debtors and insolvency practitioners. And AIB has also taken on additional tasks following legislation passed by the Scottish Parliament. Reforms introduced in 2015, implementing the Bankruptcy and Debt Advice Scotland Act 2014, resulted in new functions conferred on and transferring to the AIB. And the aim was partly to reduce burdens elsewhere in the system, not least the Scottish courts. AIB now consider applications for recall of bankruptcy, the award of shorter-term bankruptcy restriction orders, and applications to cure defects in procedure. And these were all previously preserved to the court, and there has been no increase in resource or staffing to support this increased workload. Hence, not only have staff numbers been falling, this is in the context of new responsibilities and IT investment having been successfully deployed. Turning to the cost of administering bankruptcy procedures, I'm aware of some of the concerns that have been raised by witnesses relating to the fees charged and the realisation of assets, and I note those concerns. However, as the committee may already be aware, the administration costs charged by AIB for insolvency cases in Scotland are significantly lower than those that apply elsewhere in the UK, and will remain very considerably lower even after the proposed changes. I will now set out the relevant differences from the approach taken in England, Wales and in Northern Ireland, 2 separate jurisdictions for this purpose. Where assets are realised, the sums potentially available to creditors in Scotland far exceed the equivalent figures in England and Wales, and I would be more than happy to provide further information to the committee to support this. I believe a table may have been provided this morning, but I hope that that will be helpful in our later debate. But at the outset, I should state that AIB has made a firm commitment to ensuring that debt relief mechanisms in Scotland are accessible and that financial barriers to entry are minimised. This recognises that it's often the most vulnerable within society for whom debt relief and insolvency present the only option to provide a fresh start. In April 2015, AIB introduced the minimal asset process, a low-cost mechanism to access bankruptcy for those with few assets and no disposable income. The fee charged in Scotland for this scenario is £90. The general upfront fee to access bankruptcy in Scotland is £200, By comparison, in England and Wales, upfront fees to be met by debtors are £680, i.e. 240% higher than in Scotland, and in Northern Ireland the fee is £640, 220% higher than in Scotland. The upfront costs for petitioning creditors are very considerably lower in Scotland too. These costs are £563 here, as opposed to £1,270, or 126% higher in England and Wales, and £850 in Northern Ireland, 51% higher. So it's worth stating that when looking at realisation of assets, the overall costs of administration, including commissions, are very considerably lower. In Scotland, this might amount to £3,936, or 39% for realising £10,000 of heritable assets, where it would amount to £8,292, or 83% cost for an equivalent process under the Insolvency Service in England and Wales. So a 43.5% difference in the share of the asset value taken in England and Wales as part of the process. For a £100,000 asset, the difference is less eye-watering, but the costs in Scotland are still substantially lower, with the effective cost being 13.9% of the asset value realised in Scotland, but compared with 21.8% in England and Wales, taking 7.9% less of the assets realised value in Scotland. So, Convener, we're very conscious of the need to keep the costs down where we can do so, and I think it's important that we continue to preserve low-cost access to debt relief for debtors, and with no proposed increase, the proposed regulations do exactly that. I believe that these regulations set out a sensible and equitable approach that reflect the challenging context for public finances and adapt to changing case numbers, but support the continuation of a fair and just debt relief mechanism in Scotland. And no one would choose to increase fees without good reason to do so. However, the fact remains that the costs required to be met, and my belief is that it would be unfair to instead levy further upfront costs that would act as a barrier to accessing debt relief in the first place. And it would equally be unfair to put this all at the door of the taxpayer. The proposed fees regulations, coupled with the ongoing efforts to achieve efficiency savings, represent the most effective approach, while leaving more of the asset value after costs than is the case in England and Wales. And my colleagues and I, or colleague in this case, are happy to answer any questions or expand further on the points that I've raised in this information. Thank you. So apologies for the long statement, but hopefully it's a helpful one.
Thank you very much. That gives a context to your position. And I'll come to a question from Jackie Bailey, first of all.
Thank you, Convener. I wonder whether I could explore with you, Minister, creditor petitions, because we heard evidence this morning that between HMRC and local government, this accounted for something like 2/3 of creditor petitions. We also heard that the HMRC are seriously considering withdrawing from the accountant in bankruptcy and seeking assistance from insolvency practitioners in private practice. This is also being followed by local authorities. That makes me wonder about the sustainability of the AIB, given that as prices increase and charges increase, so customers will go elsewhere.
Well, I mean, I think these are important points. It's a pity that Mr Dennis is not here to take forward the issues. I know he's been in discussions himself with HMRC around these particular matters, which we've discussed in ministerial meetings. Clearly, we're trying to maintain a balance of having competitive fee structure and trying to work. Clearly, HMRC work very effectively with the AIB, and clearly we value that relationship, which works, generally speaking, extremely well. So, you know, we would look to discuss and understand the concerns HMRC have, but I'm not anticipating, and this is a very timely arrival for Mr Dennis, but I'm not anticipating that there's any immediate issue, but it's certainly something that we would need to take into account. For Mr Dennis's benefit, just arriving, we're just discussing the issue of creditor petitions and the dominance of HMRC in terms of the work that's done through AIB and threat to withdraw from working with the AIB. But you know, I believe the package we're putting forward today is proportionate. As I say, it's about making a correct balance between the taxpayer funding of the service of AIB, reflecting the drop-off in the number of cases in particular categories, and the need to cover the costs of the organisation while maintaining, and we don't obviously want to reduce the effectiveness of the organisation by continuing to see numbers of staff fall. So it's getting that balance right, and I think we have got a proportionate system, hopefully one which delivers more for the creditor ultimately, that hopefully leaves some assets left for the debtor as well after of creditors have been paid. That's less likely to be the case in England if 82% of the value of a £10,000 debt is, or £10,000 asset is taken by costs and fees and commission before we even start to pay the debtor, pay the creditor back.
Can I maybe push the Minister just a little bit on this, and maybe Mr Dennis, now that he's arrived, might help you. I am genuinely interested in, is there a plan B? Because if HMRC do withdraw, and if local authorities then seek, alternative arrangements, that's a big chunk of the work of the AIB gone. Do you then take that monetary value and spread it amongst, the rest of the debtors, or is there a different plan B?
If I take the point entirely, and that we need to prepare for a scenario such as that. I hope that scenario doesn't unfold, but if I can maybe bring Mr Dennis, because as I said earlier, he has been discussing this issue previously.
Thank you, Minister, and my apologies to the committee for being held up on various motorways in the snow today. Am I right in the fact that Ms Bailey is picking up comments in the DISIF minutes from HMRC suggesting they might look to appoint their own trustees?
And in evidence from ICAS this morning.
Yeah, which is quoting those minutes, I think. So you'll be aware that creditor petition fees come in two parts. You pay £150 up front, you pay a further £300 if AIB is appointed trustee. And HMRC's suggestion was that increase to the further £300 might cause them to think again. I think it's extremely unlikely to come to pass. We make a loss on the majority of creditor cases, so they'd have to find someone ready to take that work on. We also pay a substantially higher dividend when AIB is trustee compared to private trustees, around about 20% in terms of dividend back to creditors. I will be very surprised if they manage to find IP firms ready to take it on for just an extra £300. But as I say, we make a loss on these cases, so if they can find someone else to do them, all to the good.
So are the sabre rattling?
I suspect they were giving an initial reaction to proposals put in front of them. No one likes to see fee increases. It's fair to say that I would like to go back to the office and consider my options. I think that's all they were saying.
So we've no guarantee that they will continue to use AIB, or that local authorities will?
We have no guarantee, but as I say, we deliver a better service and in terms of returns to creditors and in terms of lower cost than most insolvency practitioners. Now, that's partly because insolvency practitioners take on more complicated cases. HMRC tend to be very aggressive creditor, and it's not always the more complicated cases they're pursuing.
Thank you. And Mr Dennis, the Minister was given an opportunity just to make some comment on the ICAS and Govan Law Centre submissions. I don't know if you wanted to make some preliminary remarks now that you're here, or whether you're just happy to respond to questions from committee members. I'm content either way if you're...
Thank you very much, Mr Chairman. Given your short time already, I'll answer questions, and if I may have an opportunity to come back with anything I want to add at the end, that may be save your time.
Yes, all right. Thank you. And I think the Minister referred to a fee structure table which had been sent to the committee, I think, this morning, which has now been passed to members, a copy of that. I'll now come to a question from Ash Denham.
Thank you. You will be aware, no doubt, that we took evidence this morning from, among others, from Mike Daly, who's at the Govan Law Centre. So I just want to read you a couple of remarks that he made and just get your comments on that, if I may. So he said that the policy objectives in this case should be, for the fees to be appropriate and fair, and he felt that in his mind some of the increases didn't meet those objectives. So he gave an example of cases where there was, for instance, a £60,000 home equity. And he said that that's going up from £2,800 to £8,000 in fees, which represents a 183% increase. And then he said that in those cases, the money left from equity, where people obviously could be in substantial hardship, meant that the money that they've got available to sort of start over would be quite reduced. I'm just wondering what your comments would be on that.
Well, clearly, I think, Convener, and to Ash Denham, I would say that nobody takes these decisions lightly. I certainly have had discussions with accounting and bankruptcy around this issue, because I know there's great sensitivities, and I should state, not probably commonly known, but as a child I went through this as well, as part of a family that lost their home through debt issues. So believe me, I don't take it in any way lightly. But, you know, we are sitting in a situation where at £60,000 in the table we provided today, with slight difference in terms of Mike Daly's figures in terms of the table. He's starting from a slightly lower point if you add in all the fees, commissions and so forth, with a different starting point. But we're not denying there's a significant increase in fees. But we still end up with a position where there's £4,227 more being left for either the creditor or the debtor after the changes that we've got in place than is the case in comparable jurisdictions like England and Wales. So we are trying to be proportionate. We are obviously conscious of the fact that obviously, as Mr Dennis has outlined, not fully covering the cost of cases, the administrative cost, we make a loss. But we are trying to at least make sure that the pressure on public resources is managed as best we can. But we are mindful of the impact for individuals, and relatively small number, thankfully, of cases where evictions are required annually, and there are safeguards to try and protect people who are in hardship and to prevent an unnecessary loss of their family home. But perhaps if I could ask Mr Dennis to comment on, he may be aware of that kind of scenario that has been described by Ms Denham, and may be able to give some guidance as to how that would be handled in practice.
I mean, I think it's worth repeating the point that it's a tiny minority of cases that have any assets in them at all. The vast majority of bankruptcies produce nothing for anyone. I mean, I have some figures with me, I think, which show that these changes in commissions would have affected less than 1% of cases in 2015-16.
I think, or did you want to follow up on that? Gillian Martin.
Okay, in the submissions to the committee and some of the evidence that was given by the previous panel, and this is a question for Richard Dennis, people who've submitted and our panel members this morning have highlighted that they think that there is a conflict of interest for the AIB, given that it's also a policy advisor to the Scottish Government, a quasi-regulator, provider of trustees services, decision maker and appeal adjudicator. This is coming from David Mingus's submission to us. I'd like to give you an opportunity to respond to that.
Well, I'd say two things. First of all, we have just finished a very extensive programme of bankruptcy reform, which the Parliament has discussed at great length. And the decision to transfer those powers from the courts to AIB was a result of the 2015 Act, which has now been taken forward into consolidation. That followed an extensive period of consultation. So, you know, the Parliament went into this knowingly with its eyes open. The second thing I'd say is that whenever AIB takes the decision, we move powers out of the courts, but we left a backstop appeal to the sheriff. Now, we move powers out of the court because AIB is less intimidating for people who want to seek for a review. We're far quicker and we're also cheaper. But that doesn't stop people going to the sheriff for a review if they don't like the decisions and the reviews we've been through.
Okay. And just a follow-up question, you mentioned the consultation as well. Where, for example, obviously quite a lot of the creditors would be like small businesses, was there any kind of consultation that included the views of, say, the FSB or any other organisations that represent small businesses?
The consultation I was just referring to were the ones in the run-up to the big bankruptcy reforms culminating in the 2015 BADAS. In terms of these fees, we do have representatives of them on DISIF. I believe the committee had a paper from SPICE listing the members of the Debt and Insolvency Stakeholder Forum. I don't think the FSB themselves are there. Usually because of the spokespeople for the small creditor tends to be credit unions who are strongly opposed to practically all debt write-off for obvious reasons, because they can they really struggle to afford any loss of investment. But yeah, they are most unlikely to be affected here by the big changes in fees here.
And given that the people who are here this morning have been asking for another consultation, a full consultation on this, would you like to respond to your views on doing that?
In terms of AIB's conflict of interest, I would say we have already committed, we will be reviewing the impacts of BADAS in full. Bankruptcy cases take 4 or 5 years to run through, so it's perhaps slightly too early to start to look at the impact of that Act. But as I say, nothing has come up that wasn't foreseen. The safeguard is there. It has not been used. No one has actually been through an AIB review and reconsideration of a case after that and then gone to the sheriff. So those options are there, but they're untested. And while they're untested, that rather suggests to me the system is working as intended.
Thank you.
John Mason.
Thanks, Convener. And if I could start off with the point about interest that the Convener raised, the 8%. Now, if I'm understanding your answer, Minister, you said there's going to be a review at a UK level of the judicial rate, which is also 8%. Now, if that, say, brought it down to 6, would ours automatically come to 6, or is ours fixed separately?
Well, I mean, I don't. There's not an automatic link, but I would probably put it this way to Mr. Mason. I would want to see if there is a decision that the judicial rate comes down, then I would be looking to work with the accountant in bankruptcy to review the rate that's applied. I would go back to the point that's made earlier on that we're talking about a relatively small number of cases where this is applied, and it's for persistent non-payment of fees and so forth. So it doesn't apply across the board, but it is in a targeted way to try and encourage those who perhaps have a history of not paying to pay. So you don't want to lose the incentive, if you like, to pay. But I do think we need to be to reflect on any decision that's made around the judicial rate of interest and see if that has implications for the rate that's applied here. But I wouldn't want to put it overly strongly, and it's not an automatic linkage in the regulations to it. But it was something, obviously, that we would come back to look at if there was a significant reduction in the judicial rate of interest.
But if the two are separate, and if we think that the 8% is too high, or you think the 8% is too high, or all of us do, why are we waiting for the UK review? Why can't we just go ahead and go for 6 or 4 or 1.5 above base or something?
Well, I mean, I take that point. It's something that certainly occurs to me, but I think it's because it's a rate that applies in a very targeted way, and I don't have the depth of knowledge as to how many cases that would be applying to, and perhaps I can come to Mr. Dennis in a second, or to Mr. Fisher, who's aware of the court case that was referred to earlier by the convener as to the relevance here. But I'm certainly keen to reflect if it does conclude, the exercise at UK level does conclude that the judicial rate of interest needs to be significantly reduced, given the gap between base rates and the judicial rate is probably if not an all-time high, certainly a very substantially enlarged gap, then we'd maybe to reflect on that. But if I could maybe ask Mr. Fisher to come in with Mr. Mason and convener's consent.
Can I just ask Mr. Mason, just to make sure we've understood your question correctly, is your question, if the judicial rate of interest was reduced, would we automatically seek to or reconsider reducing the amount of interest charged on the late payment of debt, which is a separate issue?
Well, my first question really was, would we need to seek anything, or would it just automatically work through? But I think I've got a fairly clear answer. It wouldn't automatically work through.
That's
so
right.
we would then need to make, or you would then need to make a conscious decision to do something, but that would be one of the input factors, if I'm understanding correctly.
Yes. That's what I was trying to get.
And therefore, because it's not automatic, I was then kind of wondering, well, why are we tied to that at all? But I mean, I accept the answer from.
Yeah. I don't know if it's worth me saying something about the different contexts, I suppose, in which this fee rate is applied. There were a few points that the convener made earlier, in particular about the fact that there's no discretion analogous to what the court has when the judicial rate is applied. And I suppose I would flag up the fact that there's express provision that we've added to the regulations to allow the fees to be waived in Regulation 10.4 in the regulations. And in particular, I think the ICAS evidence was raising questions about the implementation, and as the Minister's referred to, this is really about a very small number of cases where there's a persistent non-payment of fees, and the analogy that the Minister referred to in terms of court fees, for instance, which are not paid. I mean, trustees are bound under the regulations as they stand to pay the fees at a particular time, and this is for cases where those fees have in fact not been paid. So it would be possible, to waive the fees in particular cases where there was a problem. The rate of the fee is pitched short of the rate in the Late Payment of Commercial Debts Interest Act as it stands, and ICAS, as I mentioned, we're asking for, I think, reassurances about the implementation of the fee rate in practice, and certainly, as the Minister said, that this has really raised a couple of cases, and gave the example of that two debtors account for 59% of the debt which is due for more than 30 days, which is the only case in which this fee rate could be applied. And on that basis, the the fee rate and the ability to apply the fee rate would be implemented reasonably and interest waived if there was a reasonable excuse. Already AIB have the ability to report trustees to the sheriff for a censure where there's no reasonable excuse, and that would apply in cases where fees haven't been paid on the due date. So absolutely, I think it would give the assurance that ICAS are seeking that these would be applied reasonably.
But that would just be entirely discretionary. So there's no right, as there is, for example, in a court case, to apply to the court to reduce the amount of interest. There's no right to do that.
There's no right, but AIB would have to consider the case, and if it was an unreasonable decision by AIB, I mean that could be judicial review like any decision of an administrative authority. But I quite take your point that there's no court directly involved, but I mean these are fees, I suppose, that should have been paid initially and are past payment.
Yes, well, forgive me, but judicial review would not be a reasonable way of reviewing such a decision, because that would have to be taken in the Court of Session. The cost would be prohibitive, surely, in almost every case. So, I mean, that's not a...
All I sort of refer to it in terms of the fact that it constrains the AIB's freedom of action in terms of setting the fee rates.
My other point, if I may, Mr Dennis, you said that you're making a loss in a number of the cases, and I'm assuming that because there's a scale of fees, that means where there's less equity, you're making a loss, and on the where there's more equity, you're making a profit, kind of thing.
The vast majority of bankruptcies produce nothing, yeah. Most
produce nothing, right. So can you tell us what the cost then of an individual case is, or do they vary hugely?
They do vary hugely. I think I do have it. If I were to guess off the top of my head, I would say our administrative costs are around £1,500 a case.
Right. So, and that's based presumably on that kind of average hours and an hourly rate and all that kind of thing. So, if you're getting £1,500, you're kind of breaking even, but there'll be fixed costs which you have as well. I mean, are you convinced that your fixed costs have been reduced as much as possible? Because that's been kind of the crux of some of the questioning, that as you get fewer cases, your fixed costs have to be spread amongst fewer and fewer cases.
That's an entirely fair comment. It's perhaps no surprise to members of this committee that every spending round, the Scottish Government puts agencies unlike mine under huge pressure to make sure that they are not giving us more public money than they need to. We have met our 3% efficiency saving target set by the Scottish Government and signed off by Audit Scotland in our accounts every year since 2010. So yes, we are doing what we can to squeeze costs.
Is that 3% on top of the fall in caseload, which
yes,
for other organisations would
that's 3% against the budget the Scottish Parliament votes for me. So regardless of my income.
Is your budget falling in line with your reduction in cases, and there's another 3% reduction on top of that, or is your budget just falling by 3%?
My income from cases is falling in line with the reduction in the number of cases. My budget is something separate because it is kindly topped up by the Scottish Government and the Scottish Parliament. It's my overall budget against which I have to save, demonstrate a 3% efficiency saving.
So as your caseload falls and you get less income, you just get more money from the Scottish Government?
Or by putting up fees. And it's getting the balance right. That's the crux of the matter here.
Okay, thank you.
That refers back to the points I was making in my opening remarks. And just to emphasise the point, as examples of efficiencies, the public-facing IT systems that I mentioned that the accountant bankruptcy have developed in the last few years have also helped the insolvency practitioners, accreditors, and hopefully debtors as well save costs. So it's helping from the side of the client, if you like, as well. But it has helped with the operational efficiencies within the organisation.
Gil Patterson.
I mean, it's just a small point back to the interest. I noted that you said this new order would give you the powers to waiver. Does it, with a discretion to do that, but does it also give you the ability to reduce it in some fashion? In other words, vary it?
Mr. Dennis to comment on that.
De facto, yes. because say my two large debtors who I would like to chase owe fees on a huge number of cases. So if I were to charge 8% on the £100,000, say it's overdue for 120 days at the moment, they could say to me, well, we'll do a deal if you waive the fee on these cases but not on those cases. Or if you waive the interest, we'll pay tomorrow, either of which will be fine. And what we're doing is creating a stick here to make people pay the court fees that are statutorily due, rather than stretch them out as long as they possibly can.
Okay, that's fine.
Andy Whiteman.
Thank you, Convener. Three questions. First of all, just a question for clarification from the Minister. You mentioned in your opening remarks a sum of £207,000 to offset the forecast declines in operational income of what we have in the business and regulatory impact assessment of 1.3 million 27-18, 4.2 million 2018-19, 3 million 2019-20. Can you clarify that £207,000 is the additional funding arising from the new fees from these regulations that would offset this deficit in each of the years going ahead?
It's really, Convener, it's really just to make the point that in the absence of this, would have had to find a further £207,000 of public funding to help top up the AIB's budget. So it's.
But that is the amount the fee increases bring in the first year.
Okay,
it will grow to over 800,000, I think, in 4 years.
Okay, so, thank you for that. That's very helpful. Second, we heard evidence this morning that the impact of these fees in the business and regulatory impact assessment doesn't appear to take into account the behaviour changes that might arise in those making applications. Some people might be deterred, etc., and that hasn't been properly taken into account. And given that those are the people in fairly vulnerable situations, that's a pretty important impact. Do you want to comment on that?
Me initially, and then I'll bring Mr. Dennis in. I think I've tried to emphasise we're trying to avoid putting up upfront fees for debtors to seek help and to address their issues. So we want to allow people to act responsibly. Many obviously want to sort the problems out, get their life back in control and move on from whatever problems have arisen. So by avoiding putting upfront fees, obviously in England, Wales and Northern Ireland, the upfront fees are much higher than they are in Scotland. We believe that's the right balance that we've struck here in recovering costs in the realisation of assets, and it's a very limited number of situations, just to emphasise the point, where we actually get anything in terms of realisation of assets. But where that does happen, we're leaving more of the asset for the creditor and indeed the debtor as well. So we're trying to get right at both ends of the equation, lower upfront fees and taking less of the asset value in the process as well. So we're bearing more of the cost, if you like, of the case than is the case apparently in England, Wales and Northern Ireland. So I think that's the right balance, but if I can maybe bring Richard in on the point that you raised.
I mean, again, the Minister's made the key point, which is we're not increasing debtor fees, unlike our colleagues in England and Wales, the upfront fees. The only people who might be potentially put off seeking bankruptcy, and bankruptcy is a very significant step, and people should only be seeking debt relief if they genuinely need it, are the very limited number of cases where actually once the assets have been realised, the debts are covered in full. In 2015-16, there were only 260 cases where that was the case.
Okay, and my final question is, some of the concern appears to have arisen as a consequence of the fact that the framework within which these fees are set appears to be a rather arbitrary one in terms of forecast income of the accounts in bankruptcy and how much they feel they can recover in fees. In other agencies of the Scottish Government, for example, Registers of Scotland, who have full cost recovery, they have a system where the property market is very busy, that they put aside funds in reserves and they draw on them when the property market goes down. In other words, they have a system in place to manage finances in the face of fluctuating income and fee orders, which are then set by ministers again according to a system that's fairly well understood. This seems to be a rather ad hoc decision with very little kind of framework around it to say this is how we set fees.
Well, I think it'd be fair to say that in the defence of AIB, it's very difficult to predict exactly how many people will obviously run into insolvency or bankruptcy situations. So that in itself is quite a difficult thing to forecast. Obviously, have a kind of I guess, a rough idea of how the economy is going and make some predictions, but I wouldn't want to rest entirely on that. It's also the case, I suppose, that Registers of Scotland are and others are attracting fees from positive things in terms of people obviously transferring assets, which is something that's a key part of the economy in a market economy, and therefore they're raising fees in a positive environment. If we were to build up fees, for example, to the point where you could provide an endowment or a fund that would allow AIB to, or indeed to find funding to endow AIB so it had a float, if you like, that it could manage its finances over a period of time, that would either require significant investment by government up front to do that, and I appreciate that's a choice people could make to do that. Or alternatively, it would mean you'd have to significantly increase fees to allow a significant margin to be built up over time, so that you could do that. And at the moment, we've got, I think, probably got the correct balance, and that we're adjusting as we go on year to year the budget requirement that AIB needs to ensure that balance is right between public funding for a core service that needs to be provided to help people in very difficult circumstances versus recovering some of the costs in a fair way, I hope, to help repay some of the costs of the administration, but not making a profit. So I think we have to at some point decide, do we want to go down a kind of market approach where you free up AIB to build up a war chest, if you like, and have to raise that from cases, which might mean that we have higher fees like in England, or do we continue to strike the balance that we've got, which I think is the right one, where we keep the cost down. But I don't know if Richard has a view.
Just to be clear, I'm not advocating that AIB follow registers.
Didn't think Mr. Whiteman would be.
Just saying there is an understandable framework within which costs are allocated and fees set.
I believe there is. I mean, I appreciate it doesn't have the clarity or transparency, perhaps, as the relationship that has been described with Registers of Scotland. But I think we're trying to keep the balance right in terms of making sure that we provide enough funding at with reasonable costs being recovered from cases without causing additional difficulty for those who are affected by debt or indeed the creditors.
Right. I think we have possibly time. We're slightly, I think, running a bit longer, Minister, but is it all right if we perhaps take a few more short questions? First of all, Bill Bowman, and then Gordon MacDonald and Richard Leonard.
Well, thank you, Convener. I perhaps didn't fully understand all the explanations, but earlier evidence spoke about the income from, or the increase in the income from these fees cross-subsidising other things you do. Is that correct?
Mr. Dennis.
I think the answer to that is no. I think what the other evidence was referring to is among the package in front of the committee, there is one fee where we are imposing a cap, which is the audit fee, which we think will cost us around about £86,000 a year in income. Now, clearly, had we left that particular fee without a cap and had the £86,000 coming in that way, we could have offset and reduced one of the other fee increases we have put forward, or we could have asked the Scottish Government to find us more money. We've put together a package here which we think is a fair package to raise about £800,000 in total by the end of the 4-year period where it's all in full. Actually, the certainty is we will still need more funding from the Scottish Government to top up our budget in the coming spending round. And I look forward to, no doubt, trenchant discussions with the Minister about quite how far he's prepared to go and quite the level of efficiency savings he will expect us to deliver.
Thank you. So when the Minister, and I think maybe you mentioned new responsibilities coming to you from the recent Act, they are fully funded elsewhere. Is that what you're saying?
They're funded within the mix of our income. They are not being specifically funded from these fee increases. They were new responsibilities that transferred to us in April 2015. So
some of the fee increase will go towards them.
I suppose if I could maybe just say that I think when I mentioned that earlier on, it was the context of staffing numbers and saying that staffing numbers had fallen, but new responsibilities have been taken on board. So I think it was just in case impression given to the committee that the staff numbers were only related to the casework, which is as been discussed today. There's other functions that AIB perform for government, and indeed all the innovation in respect to the IT products that are public facing as well be going on. So I thought it was an unfair analysis of the staff numbers that had been provided, so I was trying to explain that.
Gordon MacDonald.
Just wanted to ask about your cost base. So the information we've been given this morning is that you've had a 20% staff reduction since 2009, but your caseload has reduced by 63% in that same period. And given the investment that you've highlighted in new technology and IT, are you satisfied that staffing levels is at a correct level?
Broadly speaking, as Chief Executive, you'd expect me to say yes. Just one point of clarification. In terms of the caseload, the new cases have fallen by 63%, but most bankruptcy cases run for 4 or 5 years. So the stock has actually declined far less than that.
Right. So can you give us an indication of what it was before and what it is now over that period of time?
Across our entire caseload, so including protected trust deeds and the debt arrangement scheme, there are about and this will be within a few thousand, so given the committee gives us about 55,000 cases currently active, and there would have been about 65,000 at the peak.
Right, okay. So there's still been a reduction, but it's probably more in line with your staffing levels reduction. Is that what you're saying?
The figures I have here, which say that 2015-16, the total caseload, which takes on the historic cases that Mr Dennis has referred to, had reduced by 5.6% since 2009-10, where staff numbers have reduced by 19.6%.
Right, okay. And my final question, therefore, is if we were to move to annul the bankruptcy fees regulations, what would the impact be?
Well, obviously, we would have to find additional resources to make up the up to £800,000 that will be recovered by 2020-21, is it?
No, I would hope if the committee were to do that, where they would say which elements they disapproved of, and then we would bring forward a new package.
But ideally, I would encourage the committee not to do that if it's possible. Hopefully, I mean, we have set out that you know, it's nobody, as Mr Dennis has alluded to himself, nobody likes to pay fees and nobody likes to pay costs for such actions, but we've tried to keep the balance right, so not putting up upfront fees to ensure that people who need support to clear their debts and to get back on the straight and narrow can do that without a disincentive, but at the same time not recovering as much of the asset values for our costs and commissions as happens elsewhere in the UK. So we are, the costs have gone up and we acknowledge that, but it's not something we've done lightly, and it's also we've tried to keep the balance right and reduce the take from those assets being realised to ensure that creditors and indeed hopefully the debtor will get something back if that's possible.
Right. Sorry, Richard Leonard.
Yeah, the Government Law Centre has a reputation as an organisation which fights for social justice. The Institute for Chartered Accountants in Scotland is not notorious as a revolutionary guard, but both of them have described your proposals that still are before us as being unfair and regressive. So we have to give consideration not to how these fees compare to England and Wales, but how they compare from this year to next year. And as I read it, the Commission charge on assets realised is going to move under your proposal from a rate of 15% on the first £10,000 to a rate of 15% on the first £50,000. That's an extraordinary increase, isn't it?
I don't think I would characterise the changes in that way. I fully acknowledge the reputation of Government Law Centre and indeed ICAS are both good organisations, different approaches generally, and I'm not taking the points they've made lightly. But I'll just reiterate the point: we've got to reflect the need to recover costs to some degree. We have held costs down substantially lower than they are elsewhere in these islands in very similar both economic and legislative context, so we've got our own jurisdiction in Scotland clearly. and we believe we're striking the right balance. We are not recovering the full costs, as Mr Dennis has made clear. We have not taken these decisions lightly, and there are substantial, and I think it would be have to be acknowledged, even if ICAS and Govan Law Centre are not delighted with the changes that are going through, even they would have to, I'm sure, acknowledge the costs overall are far lower than they are in England and Wales, and the fees are far lower than they are in England, Wales and Northern Ireland. So I think we've got the balance about right.
But it's the scale, isn't it? It's 180% of a rise overnight. It's a staggering increase, isn't it?
Well, it's worth, I mean, just the point, to reiterate the point, that the ICAS have themselves said they have no significant objections to the proposals. So I take the point, and Mr Leonard may have heard something. I have not been present to hear ICAS's evidence this morning, but in terms of their written submissions, they have said they're in the paper that they have, and I quote, no significant objections, unquote, to these proposals.
But does that not mean, Minister, they do have specific objections?
I think there was the particular issue about the audit fee, I think, which was raised about the capping of the audit fee, and that as was addressed in Mr Dennis's earlier remarks. But as to the issues in regards to the table we sent to this morning, I don't think there's been a similar strong objection to those costs that have been set out there. And I'll just refer back to Mr Dennis's point about the audit fee.
Well, perhaps a final question from Jackie Bailey, and then I'll perhaps give the last word to Mr Dennis. Jackie Bailey.
Yeah, I think if you look at David Mingus's written submission to the committee, he in fact talks about interest on unpaid fees provisions were not consulted upon and not objected to in principle. However, the interest rate applied in the circumstances in which interest will be demanded do give cause for concern. He does go on to say that, you know, these things were not agreed and they didn't feel that consultation was sufficiently full. Notwithstanding that, all of the witnesses this morning said that they felt that there was a need for a fundamental review. And, you know, I wonder if I could put that to the Minister, that rather than this piecemeal approach, a fundamental review actually might give everybody comfort and satisfaction.
Certainly on the latter point, I mean, I'm happy to accept that. I think Mr Dennis made a good point earlier on about the data and needing to ensure that we've got sufficient time to understand how the measures that we're putting forward actually work in practice. But absolutely I accept that we would want to sit down and review how they have performed in practice. And if there are cases where there's a disproportionate impact on individuals, then we'd want to highlight those. Clearly some of the measures we've talked about today are provided as a disincentive, and hopefully it can reach an agreement with a debtor to make sure that debts are paid without the need to invoke you know, relatively punitive interest rates that have been referred to. But I take the point on board, and if we need to give a commitment to the committee to undertake a review at a suitable time when we have the data to do that, then I'm happy to confirm that.
Just so that there's no misunderstanding, the witnesses talked about a review in advance of these regulations being put in place. They didn't feel that there was sufficient justification, and they felt that there was a need for a more fundamental review of the approach rather than passing these regulations and then reviewing them.
It would be, if I may come in and reply, it would be very difficult to do a review until such time as we have evidence of the impact of the changes that have gone through. But I take the point and around the impact. We've hopefully, with the clarity we've been able to give today about the number of cases involved where interest rate would be applied, and the relatively small number of cases where there's a loss of a home or asset are of some comfort, and the safeguards that are put in place to ensure that that there's obviously a right of appeal to the sheriff if that is something that people feel are being treated unfairly. So there are some safeguards in place, but we're obviously listening carefully to the views of the committee, and we'll take on board the points in terms of our future policy direction.
Mr Dennis, would you like to give a last word, as it were?
Thank you very much, Mr Chairman. Just to say three quick things, I think, to the committee. Firstly, in terms of fundamental review, Parliament extensively looked at all aspects of bankruptcy over a 2-year period into the after the 2015 Act, including how we were going to charge for this. And in the November 2013 regulations, we did introduce a different model of charging. Secondly, I suspect the Minister covered this in his opening statement. I wasn't here to say it, but just to put on record that some of the things the Government Law Centre said about my agency not delivering any efficiency savings, and the staff numbers they quoted were just based on wrong numbers. They had looked at headcount, not whole-time equivalents, to warp some of their calculations. We've made very significant efficiency savings. We've seen staff numbers reduced from around 170 to below 130, at the same time as taking on new responsibilities, and we expect to see staff numbers fall further in the coming years. So we are doing what we can to drive efficiency, and we also have an enviable record in terms of delivering IT systems on time and under budget, and there are not necessarily that many chief executives who can sit in front of you and say that. Finally, I would say that I've talked about this package raising around about £800,000 over the full 4 years. That's the level we're looking to pick up fees out of around about 12 million in income now. The big elements of that are actually the basic administration fee, which brings in about £400,000, and the upfront increase in creditor petition fees, which brings in about £250,000. And as I'm sure the committee are aware, upfront creditor petition fees from the petitioning creditor can be reclaimed from the case. And I have not received a single representation from a creditor organisation, including all the big banks who will be paying the vast majority of these charges, suggesting they are unhappy with the comparison between our proposed fee increases and those in England and Wales.
But perhaps I could just clarify one point. You, I think, don't accept the Government Law Centre's figures from what you say in terms of employee numbers. Can you give us what you say are the correct figures?
73 down to 139, I think.
129, I think.
Yeah. Apologies, convener. Just get their figures there.
Full-time equivalents in 2009-10 were 173. Full-time equivalent in 2015-16 were 139. And I can tell you those numbers have declined further since those last published figures. Those ones were given because those were available to someone who'd looked at our published documentation.
Right. Thank you very much. Thank you to our witnesses. I'll now suspend this session and we'll go into private session. I'll allow the gallery to clear. Thank you.